Welcome to Don't IEP Alone, the only podcast dedicated to helping parents navigate the IEP process and hosted by a special education advocate. Your host has been attending IEP meetings for over a decade and has helped thousands of parents go from an IEP rookie to an IEP all-star. Be prepared to learn tips that will be a total game changer for you as a parent advocate and, most importantly, your child's outcomes. Partnered with the award-winning Blog a Day in Our Shoes, you'll be confident, knowledgeable, and actually looking forward to your next IEP meeting. Don't IEP alone. Get ready. Here's your host, from suburban Philadelphia, Lisa Leitner.
Hi, and thanks for tuning in. This is Lisa Leitner with Don't IEP Alone from A Day in Our Shoes. Today I have with me, I'm very excited about this, I have Steve Jacobson from Jacobson and John, which is a law firm near me in suburban Philadelphia. They are in Bucks County. And I have a whole list of questions that we're going to discuss and get some clarification on. And if you're in my Facebook group, you'll know that a lot of these questions come up often. And a lot of times we say, you know what, you really should probably consult an attorney about that. So I am very excited that we actually have an attorney to consult about that and get some overview about guidance and how to proceed if you are a parent in the situation. So let me introduce Steve. Steve, why don't you say hi and tell us a little bit about yourself and your firm?
Hi, Lisa. Well, first, let me just say thank you so much for having me on. Yes, as you mentioned, I am in a law firm, Jacobson and John. We're the education lawyers. We're located in Doylestown, Pennsylvania. We have been doing almost exclusively special education law, although we do cover various facets of law. Myself and my partner, Holly John, we have been doing special education law for over 20 years, probably close to 22. Even though I sort of landed in this area, but my background is I have a doctorate in clinical psychology, which, believe it or not, does tend to help in education law generally, especially special education law. One last thing about our background is that, and I'm not sure if you're familiar, but both my partner and I spent the first 10 years representing the school district side, and the last dozen years representing parents exclusively. Now, granted, many will say we came to the light, and that's certainly probably true, but I think it does give us a unique perspective of how things work, what districts tend to balk on, how you can get things done in the face of what districts are telling you.
Yeah, I think that definitely is an advantage, having, and as a blog owner in my site and everything, they go, oh, you make it all us against them, we against them, stuff like that. And it's not. I'm all about collaborative approaches, but at a certain point, yeah, it does become us against them, and you need to know what you're up against, and that's got to be a huge advantage.
It can be. I mean, and I think my approach, now granted, putting my psychology hat on, I tend to push to let's try to make this collaborative. Let's try to work together, if only because one of the things is this is not personal or injury law, that it's a car accident and then everyone walks away. In many cases, all the players, other than perhaps the attorneys, have to keep working together. So now, having said that, there's a time for collaboration, and then there's a time to put your foot down. So, that's sort of the balance, of course, with all of this.
Right. Okay. Well, as I said in the intro, we had a bunch of questions that we discussed ahead of time that we were going to start. So let's dig in. The first one is one, and I'm glad you're here today, because I have been taking some emails and messages from my page and group members, and they go, oh, when you tell us to get an attorney, or, the advice is get an attorney, that's not always realistic. So tell us a little bit about what do education lawyers do, and how do you decide when you might need one?
Sure. Well, first of all, I think, we have many parents who come to us who are surprised we exist in the first place. I would say not many folks ended up going to law school specifically with education law in mind, at least when I started. Now I'd say perhaps that has changed, but 20 plus years ago, it really wasn't a specialty you saw too often. But to answer your question, I mean, of course, we're dealing with education issues, but with parents, what we end up doing kind of runs a gamut. And um, I'll start by saying, I mean, typically when we see parents, whether they've come from an advocate or just off the street, typically things have gone south before they're going to see us. I mean, really south. I mean, most folks are not running to an attorney like right out of the gate. And of course, it's great. Many advocates who've been doing this for a long time kind of recognize when, okay, you need to start looking at an attorney. And I think most of the time that is when, not only if things have been going bad perhaps for a while, the elements or the expectation of change is not all that high either. That, perhaps an advocate has been working with a parent for a while and they're not seeing any change, or a parent's been working at it for a while and they're not seeing any change despite, having concerns, despite seeing maybe a lack of progress. I think those are typically when parents come to us and, for our involvement, certainly that can be a sort of a consult. We're kind of working through things with them, and we may be in the background. Sometimes the school district isn't even aware that we're helping a parent, or at least advising them. Sometimes it's just strategizing, what to do next. Sometimes it's having a parent come in and we kind of talk it through. They know something's wrong, but they don't know exactly what, or, how, meaningful that is from a legal perspective. And frequently it is us doing representing a parent in what we call a due process hearing, which I'm sure you're familiar with. Uh, you know, Many times, it is getting an attorney involved to advocate for your legal rights in a formal forum like a due process hearing. I would mention that most of the time, and overwhelmingly most of the time, uh, even though we may file a due process complaint, many times these settle in some way, shape, or form in a way that's satisfactory to a parent. Unfortunately, it has taken uh, involvement by attorneys sometimes to get things done that perhaps probably could have been done. And I'm not trying to be sort of cryptic, but my point is sometimes it just takes bringing an attorney in to kind of get the needle moving. And sometimes that's simply because you have the IEP team and you're sort of deadlocked, or you're in an impasse of some sort, and things are just not happening, and tensions are running high. Well, once you get the attorney involved, it does force the school district to get their attorney involved. So it's sort of a new set of eyes on their side too, that can hopefully help push things in a way that's advantageous for the parent.
Right. And, and that's, I think, as an advocate, I take parents through the various steps. And it might be something like as simple, or at the very beginning of the process, that the parent has never submitted a parent concerns letter. So they've never actually written down their concerns.
Right.
They've never asked for a PWN. And I'm finding a lot of cases where PWNs just aren't being provided, or they're incomplete, and the things that were denied are not on the PWN.
Right.
So, it's incremental steps, at least from my point of view, that I say, well, did you try a parent concerns letter? Well, did you ask for a PWN? Well, was one provided to you? And then sometimes, it's having an advocate attend the meeting with you is sometimes the nudge that they need. And then sometimes it's like, no, you know what, you can either, continue to let the school just tell you no, or, you're going to have to really push. And that might mean inviting an attorney to get involved. One of my definite situations, or a situation that I encounter where I definitely say, get an attorney, is, behavior at school, and the school or the other student or the teacher or whoever else was involved decides to press charges. First of all, do you do that? And if not, like, where I struggle as an advocate is recommending either a criminal lawyer or an education lawyer, because in most cases we do find that the behavior plan was either non-existent or insufficient, not being followed. One of those cases, but they also do need a criminal lawyer. So what would you recommend for families? Because that's coming up. I feel like that's happening a lot more. So what would your recommendation be there?
Yeah, it can vary. I mean, you are talking two very different areas of law. Sometimes we will get into the criminal justice system. Now, I will be honest with you, that's not our forte. Some attorneys, kind of lean more towards that. With respect to pressing charges, and you're right, this has unfortunately come up more and more. And like you said, oftentimes it's based on a faulty behavior plan, or at least faulty implementation of it. Typically, unfortunately, the teacher, whoever it is, can press charges. There's nothing legally preventing them from doing that. What your hope is, and to be honest, we've always been pretty successful with this, because I can only think of a couple times honestly, in more than a dozen years, that once we're involved, the attorney on the other side speaks to the teacher or staff member, whoever it was, who wants to press charges, and usually is successful in saying, okay, look, we'll take these steps. Let's not go down this criminal road, for the exact reason you're saying. Okay, you have this perhaps district, this small little victory. Although in fairness, I'll say oftentimes the district doesn't want the staff member to do it either. But if it happens, for the reason you just mentioned, it's potentially indicative of some denial of FAPE leading up to that point. So districts aren't real nuts about it either.
Oh, yeah. Good. That's a very good point. I guess just as an advocate, the concerns I hear is like, what are you saying? Are you saying I need two lawyers, that I need one to address the FBA issue and another to address the criminal issue? But you're saying that may not be the case, that try the educational issue first and worry, maybe talk with them. And then if the school or person continues with the criminal charges, worry about that then, kind of thing?
That can be the answer, correct.
Yes, okay.
There's certainly folks out there that do both. Not a ton, but there are some. And here's why. I mean, it's hard to dabble in our area of law in special education. So it's hard to do a lot of other things. So, by necessity, yes, you do get involved in some of these other areas of law, but it certainly could be that you do need two attorneys, depending perhaps on, how complex is that criminal issue.
Right.
And so, and we've certainly worked with criminal attorneys and, sort of in terms of what's going on, and kind of work jointly.
Okay, great. Okay, from a legal standpoint, I know what tips I give, but from a lawyer's point of view, how do you think parents can most effectively advocate for their kids on their own, without an advocate, without a lawyer?
Okay. So what I see, to me, the first thing that a parent needs to do is have some fundamental understanding of their rights to begin with. Okay. Now, it's easy to say, hey, go read the procedural safeguards. I recognize that's not an easy way, but the parent is by far a child's first and best advocate in every situation. I mean, as nice as it is to think that the school district, even the best of school districts and the best of circumstances, are totally on top of everything, in my experience, it really does come down to the parent. Are you looking over things? Are you monitoring? Are you on top of what's happening with your child? If you take a completely hands-off kind of approach, we certainly see that with parents at times, that, I didn't know, I didn't listen, or, yes, I'm sure they probably did give me the IEP. I don't really have it anymore, or what have you. I would say the sort of primary things for any parent is, it's hard to go to an IEP meeting, which for anybody, I mean, it's a lot of, folks at the table. It's sort of you against, and sometimes, and yes, everyone's collaborative. yes, everybody's a team, but you're one part of the team that can sue the rest of the team in a sense. So you're not exactly on the same team, I guess I would say. So as a parent approaching this, I mean, you want as much information as possible. So that could involve, okay, knowing your rights generally. Are you aware as a parent that you don't have to sign the NOREP that day sitting there, even though the district probably really wants you to, just administratively, they don't have to track you down for it. Do you know as a parent that you don't have to, um, you know, sign a NOREP until you get the IEP to begin with? You don't have to sign for an IEP in the abstract. Do you know that you get time to review an evaluation? Those kinds of things. But I mean, obviously, there's lots of basic things, but I think it's much easier to find online and educate yourself than it used to be. Planning and preparing for a meeting, quite frankly, is like, don't walk into it blind. Or if you have just one issue, have read things, have been on top of things. I always tell parents, keep written records of things, have a paper trail of things like leading up to, is this an IEP meeting because there's a problem, or is this an IEP meeting because it's just the mandatory one that the district's doing annually? You want to have a plan going in, and that can include, which I find, parents don't think about, talk to your child. I mean, many times, kids are old enough or, have enough insight that they can tell you kind of what would help, or here's what's working, here's what's not working, those kinds of things. I would say be prepared to ask questions if you don't understand, and listen to the answer. You can't necessarily, you listen to what people are telling you. Uh, at the end of the day, I find that the biggest piece of advice I can give to a parent is, you're, as long as you're being reasonable, you should be okay. Meaning, rarely am I telling parents to go in there, you don't want to go, well, here's what I would say. While you don't want to be too trusting, as to be gullible, I rarely recommend sort of a scorched earth approach either. It's, these are real people that you're dealing with, and, it's okay to disagree without being completely disrespectful to people.
Right.
Having said that, I get it. It's people's kids, and it's, it's your kid, it's my kid, whatever it is. It's hard to keep emotion out of it. And, kind of going back to why you would have an advocate or an attorney to begin with, sometimes that it's that simple. Like, it does come down. It's very hard for parents, understandably, to not insert a lot of emotion into these decisions and meetings and things like that.
Right. One of the pieces of advice that I give a lot of parents is, I say, channel Michael Corleone. It's just business, and you have to get into a mindset that this is. And I said, don't off your family, but yeah, this is a business meeting, and you have to get yourself in the mindset that this is not, for as emotional as this is, and I live this life myself, that this is a business meeting, and I'm in the business to get my child's needs met. And we don't cry at business meetings. It's while that happens, and I'm not shaming anyone, it's about changing that mindset.
But that's a great point. I mean, and I think you kind of hit it on the head. I mean, that's a great way to look at it, is that, look, it's okay to be passionate. It's okay to be, obviously advocate the best you can. But, go in there. I mean, presumably you're not going to go into a business meeting having no idea what's going on, or not preparing for it, basically. And there's a lot of ways parents, as I've kind of mentioned, can prepare for these things. And I find that if you know what you're talking about as a parent, and again, you're not, going over the top and, as to be uncooperative and, completely confrontational, logical responses and reasonable questions, to parents' surprise, are sometimes met with logical and reasonable responses.
Yeah.
It depends.
Right. And you're right. In the scorched earth, and, I say, put away the pitchfork. That's not what we're here for, but using the process. Like I said, doing, like you said, have a paper trail, ask for the PWN, the NOREP, and use the process rather than going in there and just getting upset and then leaving, which is, I think, what happens, unfortunately, for a lot of parents.
I think you're right. And, one thing I do tell parents is, and I'm sure you say the same, is look, at the end of the day, this is for your child. This isn't your hurt feelings. This is not, anything. And, I'm not going to curse, but it's not, when you go to these meetings, it's not illegal for, an administrator to be a jerk. Okay.
Right.
I was going to use a stronger word, but that in and of itself is not illegal.
Right.
But don't rise to the bait either. You're there for your child. You're not there. No one's there because, hey, this sounds like it'd be great to have a meeting today. I mean, that's why you're there, and use that to motivate your focus.
Right. IDEA does not address courtesy or manners or anything like that, or being polite.
Unfortunately, it does not.
No. Okay, let's get into the nitty gritty of some things that I think there's a lot of issues and a lot of parts of IDEA and special education that are really misunderstood by parents. One of those is unilateral placements. I refer to them just as the 10-day thing.
Sure.
But I do see a lot of information being tossed around online that says, one parent advising another, like, pull them out and enroll them in a private school. The district has to pay. And I'm like, don't, please don't do that. So can you explain to us a little bit about what a unilateral placement actually is and how it works? And if a parent, and this is another area where I recommend that parents at least consult with an attorney before doing this so that you're not left holding the bag and the invoice for tuition. So can you explain to us, if a parent is considering this or they've heard this advice, what it really is and how to use it?
Absolutely. And I think you are 100% right. This is an issue that is sort of fraught with potential pitfalls and ways to kind of screw yourself as a parent, where perhaps if you understood sort of the lay of the land better from a legal perspective, you may have ended up in a different place. And I think, just to comment on one point you brought up, which I think is exactly right. One thing we always tell parents too is, obviously, look, seek information wherever you can, find out as much information, as possible about things. But it's dangerous to put yourself in someone else's position, meaning, as you mentioned, another parent said, hey, this is what they did for me, you should go do it. And this is how I did it. Well, all these situations, as I probably don't have to tell you, tend to be very factually driven and very case by case. But to answer your question, okay, so would a unilateral placement, or what we probably on the legal side more call like a tuition reimbursement case. Basically what is happening is, as you've said, that a parent is unilaterally just removing their child out of the public school system for whatever reason it is. Usually for what it's not. Typically, it's just the parent doesn't believe the program or placement's appropriate for the child at the public school, and maybe their child's having a lot of problems, not making progress, whatever the case may be. Well, one of the legal landmines is potentially, and I guess maybe one thing I will back up is the analysis that is going to be reviewed or taken by someone called a hearing officer, if this ever got all the way to a hearing, is as follows. It's basically a 3-factor analysis in terms of whether or not I can get the district to pay for my private placement where I have already placed my child. Okay. So that analysis is the first thing a hearing officer would consider is the district's IEP appropriate? Okay. So let's say you've decided, okay, I took out my child, I put them in X private school. I'd like the district to pay for it. The district says no. Now you end up at a hearing because it's not resolved or whatever, obviously, and we can talk about resolution, how it might settle otherwise. But let's say you went to a hearing. The first thing the hearing officer is going to look at is the district's proposed IEP appropriate? If it is, it's the end of the analysis. It doesn't matter. You're never getting to factor 2, which is the parent's school appropriate? So first consideration is the IEP appropriate that the district offered? If it is not, then it will go to consideration number 2 is, okay, well, is the parent's program appropriate? So when you get to, let's say, consideration number 2, is the parents, you've gotten past number 1, the school district, or excuse me, the hearing officer agrees with you that, okay, the school district's IEP is not appropriate. We're going to look at number 2. What the hearing officer is going to look at, and now granted, the threshold is not nearly as high for the private school as it was for the public school. There doesn't have to be IEPs. There doesn't have to be, certain built-in legal supports and things like that. However, in order to get a hearing officer on board with you, you are going to have to show that somehow this private school is meeting a need that the public school was not. Meaning and in general, again, I hate to broad brush some of this, but in general, that means it has to be more than just being a small school. Because quite frankly, most of the time, private schools are smaller, and most of the time, most kids would do better in a smaller environment. So that's not going to tip the scales necessarily. It's a factor for sure, but it's not, if that's all you have, that's not so ironclad. But I will say the threshold for the appropriateness of a private school isn't that high. But then the last consideration that the hearing officer will look at, and this is kind of, I think you alluded to this, is what we call the equities, which is a fancy way of saying the hearing officer has some discretion and can look at, okay, does everybody have clean hands here? Was anybody, kind of playing fast and loose? Anybody playing, games? Anybody have dirty hands in this? And that's where, for example, what you mentioned, that's where the 10-day notice comes from. And what that means is that when a parent is going to think about pulling their child out of the public school system, they have to provide a 10-day notice to the district, okay, in general. Or they could also bring it up at the prior IEP meeting and say, look, this is my intention and I'd like the district to pay for it. I think they should, fund this placement. But let's assume you didn't bring it up in an IEP meeting, and because most of the time you're talking 10-day notice letters. The purpose really of that 10-day notice, and it's 10 business days, by the way, is really to give the district a chance to have an IEP meeting and sit down with you and try to address whatever concerns you have, okay? I'm surprised that more districts don't do it because unless you're so sure as a district your IEP is, flawless, that couldn't be challenged, regardless that you have a parent that has now thought it was so poor that at least, if not as written in implementation, that they've elected to remove their child to a private school, that it gives them an opportunity to kind of address some of these needs. And that's really the whole purpose of it. The school district doesn't have to do it, and sometimes they don't. But if a district is going to do it, they need to do it within those 10 days. So let's say, though,
does the parent have to? That's right. Does the parent have to attend? Let's just say legitimately within 10 business days they are unable to take a day off work.
If that's the case, anytime a parent legitimately can't do something like that, what I would say is, I guess the short answer in that instance, if they said, like, look, I'd be happy to come, and I'd put this in writing, I'd be happy to attend this IEP meeting. However, I can't for whatever reason. But what I would say is offer alternative dates that you could, okay? Because one of the things I always tell parents as well is you don't want to be overly uncooperative, okay? Or just have the appearance that you're just difficult generally. You know what I'm saying? Like,
right.
That's you. So in the instance you described, a reasonable response is, I'd be happy to attend, but I can't do any of the dates you just offered. Here's the date I would do. Now, the district might say, because you are kind of getting into some legal procedural things that they need to kind of be dealing with themselves with the 10 days, they might have it without you. I guess that's possible. It's a very gray area decision though, because if the district's not sure what is wrong anyway, but more often than not, what I find is that a parent is either saying, well, why should I come? And that's where we'll say, if you can go, you go, because then you can say, well, look, I was happy to hear what they had to say. And quite frankly, look, if they could do this IEP or propose this IEP, implement this IEP, I'd be happy to have my child in the district, but for whatever reason, I don't believe you can. The same holds true with, I would say with sort of a related thing. Sometimes parents will say, look, they propose different programs or placements. I refuse to go look. Typically, we will tell parents, go look. You can always, it's much easier to say, I looked and didn't like it for these reasons than I refuse to even consider them. And again, I'm not saying there aren't scenarios where it's so completely inappropriate placement that you could legitimately say, look, I don't see how that possibly meets my child's needs. But again, it's the, sometimes it is sort of, not putting up obstacles that you don't have to. One of the things, just, I realize I tend to kind of go off on a tangent sometimes.
Yeah.
What I was going to say, just to bring it back to the 10-day notice. Is it fatal to a claim if a parent doesn't do it? No. Okay. It's discretionary to the hearing officer. So if a parent failed to do the notice, it doesn't necessarily mean you don't have a claim, but it could be relevant. And honestly, I think it goes to, was the district generally aware the parent was dissatisfied? Maybe they mentioned it in passing. Has this, have things come up before? But as a practical matter, I would say that the importance of that 10-day letter probably varies with the hearing officer's decision in terms of whether they are planning to award the tuition reimbursement or not. Meaning, it's a lot more important that a parent, if in the case where a parent did not provide the 10-day notice, it tends to be a lot more important to the hearing officer where they were not probably intending to give the tuition reimbursement anyway. But if they were, then it becomes less important, it seems. So,
okay. So let's say my child's in an APS, so this really isn't an issue for me.
Okay.
But let's just say I'm really dissatisfied with my public school. I've been having IEP meetings. I've been sending emails. We've been chatting on email back and forth with various team members. And finally, I decide, you know what, that's it. I'm doing this. I do everything by the book. I submit the 10-day letter. And first of all, I should add, I don't know if it's been your experience, but what I'm finding is that most private schools, at least the APSs, and that's not even getting into the non-APSs, and that's a Pennsylvania term for those of you who aren't in Pennsylvania. It's they kind of have the state's blessing, and it's a different setup. I don't even know how to explain it. It's easier to get placement there rather than at, let's say, like a private. We have a lot of Quaker Friends schools who provide services for, say, ADHD and dyslexia, but they're not APSs. Sorry. Well, and I went off on my own tangent there. But let's just say I'm finding that both, at least the APSs, are not even taking the child in, or not even giving parents, they're not even giving parents that option without a referral packet. So it may not even be an option, I guess is what I'm saying, is that you look at this private school, and depending on whether or not it's an APS, even if it's not, some of them aren't even letting children enroll without the school district's blessing, so to speak, the IEP placement. But let's say I do everything by the book and I found a school that will admit my child. We go through like what happens then after I give my 10-day notice and I've enrolled my child? You just kind of wait to hear about a hearing?
Well, what's going to happen is, and maybe just to clarify, the approved private school, why that is a little different is, as you've indicated, it's totally a Pennsylvania construct, that these are schools that have agreed with the state to implement IEPs from school districts. Okay. In return, the state is paying a percentage of the cost. And my recollection, it's 50 to 60%. Okay. So they're a little different in a approved private school in terms of a parent's ability to, a parent may be able to go visit and observe prospectively, but chances are the actual application, most approved private schools are going to say it needs to go through your school district. Now, through a true private school, like you mentioned, Quaker school type, just a true private school, that, traditional private school, that would not be the case. So let's say you've done everything you're supposed to do, and your child is now in the private school. You've indicated to them that you want reimbursement, to the district. Well, one of the things is, where does a parent sit financially to begin with? Meaning, what's the risk to a parent? And one of the things, sometimes parents come to us, fortunately, where they haven't necessarily, taken their child out, but sometimes they'll come to us saying, well, here's what I'm planning to do next week. Okay. And we say, well, is that something you can afford? Is that would you be doing this regardless, and you're just hoping to get money back from the district? Or is this something you need the district to pay for because you can't possibly swing this, which is the case for most parents.
Right.
And, if the strategy just varies. So if it's the former and they can afford it, well, then, what you're going to do is you're going to file a due process complaint, through an attorney, or parents, there's no requirement that you have an attorney. Typically, I would say you do want one, though, because the district is always going to have one. So if it gets that far where you're filing due process hearings, most of the time, though, a parent comes to us, they're saying, well, here's what I'd really want because things are going south or what have you, and they really need the school district to pay for it. Now, I would say many of these cases, at the very least, how a parent can get there to the private school they want may not necessarily be because a district feels that now they couldn't provide a program for their child. It may be that in the past that the district kind of dropped the ball, okay? Where a parent could say, look, you've kind of failed my child, or in my opinion, you've failed my child for the last couple of years. Well, as you know, the remedy for that is what we call compensatory education. Well, many times you could parlay that compensatory education, kind of trade it for future programming, and that might get you the private school you're looking for. It's just another avenue to get there. And again, apologize for the tangent, but unfortunately, most of these issues are never so clean that you can say blanketly, okay, here's what you're always going to do. But going back to your scenario, let's say this is a parent because they've already given their notice, they've already placed their child, so clearly they can afford it, or at least afford it to start. Then what a parent would do is you would file a due process hearing complaint, either through an attorney, or you go to the Department of Education website and you can just kind of do it online there. Does that answer your question?
Yeah, it does. And no apologies necessary. I just had someone the other day ask me, say, can you do like write a high level thing about IEPs? And I was like, no, I can't. I said, I don't do high level when it comes to IEPs because it's all important. Hey, this is Lisa. I'm going to step in and cut us off right here. I hope you've been enjoying this episode, but Steve and I ended up talking for almost 90 minutes, and I didn't want to overwhelm everyone with a super long podcast. Tune in tomorrow for part 2. And if you wish to reach Steve between now and then, he can be found at theeducationlawyers.com. Or, of course, if you just want to do a Google search, the name of his firm is Jacobson and John. Okay, great. And I hope that you tune in tomorrow.
Thanks for listening to the Don't IEP Alone podcast. No parent should have to IEP alone. And with A Day in Our Shoes, you don't have to. For more IEP assistance and letter templates, visit adayinourshoes.com. For ongoing assistance and support, follow our Facebook page and group.
Touch me, I could fly up to the sky.
Every day I'm on my road, but today is the day that I meet you, my baby. Hope you're going to stay.
It's gonna be okay, gonna make my day. Go my way, it's gonna be okay, gonna make my day. It's gonna be okay, gonna make my day. Go my way, it's gonna be okay, gonna make my day. Go my way. It's go my way. Go my way.